Good day, my name is Sipongwe. I'm head of communication at the Competition Commission. The Commission celebrates 25 years of its existence, and we look into the beautiful work that it has done, some significant milestones, and we talk to a number of executives inside the Commission. Bakhe, thank you, man, for agreeing to have an interview with us on the 25th years or 25 years of the Commission. And we're trying to cover all the aspects. Of course, we'll talk to you largely on the legal processes, but also we may touch one or two other things outside that. But how have you seen the legal landscape developing and some of the significant aspects that have affected your approach in terms of the cases that you deal with over the past 25 years?
Yeah, thanks, Bramsipos, for the invitation. I must make it clear that I was not the head for 25 years of legal. Of course, I have been the head at least for a significant part of the 25 years, but not the full, not the full 25 years. Now, in terms of how the legal issues have evolved in competition law, I think we first had to secure adoption of competition law in the initial stages of the introduction of competition legislation in South Africa. Now, because we were in that phase of securing adoption, you then see in that period a contestation around almost each and every aspect of the Commission's work. For instance, there was contestation around rates, which chilled the Commission at some point. The Commission stopped doing rates after its first rate was set aside by the courts. So you see a lot of that contestation. Even the leniency policy, when it was introduced, it was also contested. There was legal contestation. Issuing of summonses, there was contestation. Instituting or initiating an investigation, you see contestation there. Referring a complaint to the tribunal, there was contestation there. So those, that period, that first initial phase, which I call the adoption phase, was characterized by a lot of litigation. But what has helped with that litigation is that ultimately a lot of principles then became settled as a result of that litigation. But it took time, unfortunately, for those issues to be settled. So everybody now accepts that the Commission can conduct raids, it can issue summonses, it can initiate investigations, it can refer matters to the tribunal for prosecution. But there are still, of course, other areas which are constantly being contested because of the sheer magnitude of and the impact of decisions that are made by the Commission as well as competition authorities broadly.
But in terms of those initial cases, and of course, as the cases began to settle, do you think that you were initially successful or you had to take a lot on the chin? How were the developments leading to that adoption you're talking about, where at least there was a general understanding that this is how the terrain was with regards to the legal cases involving the Commission?
Yeah, I think we learned our lessons. For instance, on raids, the criticism was that we brought in a media crew in the raid. So we don't do that anymore. In terms of issuing summonses, the criticism was that we instituted an industry-wide investigation without identifying any specific firm. So we have learned lessons from those early cases. That's why I'm saying that some of the principles then became settled after that first wave of litigation. There are, of course, other waves of litigation that have followed that initial wave, which still continue up to this day.
But generally, in terms of then you registered successes, and what informed those successes? What are the key factors in your litigation strategy that informed the successes that you registered?
Yeah, we have, of course, registered a number of quite significant successes in litigation. Of course, I can just mention a few. For instance, the Mediclinic case, which really for the first time managed to clearly set out or define the intersection between competition law as well as the Constitution. So that case was very important from that perspective as to what is the role, for instance, of the Bill of Rights in assessing a competition matter. In that case, the specific right which was implicated was the right of access to healthcare. So Mediclinic, in a sense, it's an epoch-making case. We also had cases such as Senves, which we also won in the Constitutional Court. So that case was about exclusionary conduct in the form of margin squeeze, whether that margin squeeze is a form of anti-competitive conduct that is cognizable in terms of the Competition Act. We also had groundbreaking cases such as Pickford's, which has actually helped us in terms of defining the role of what is known as the statute of limitation in competition law, where we also had Standard Bank, the Standard Bank decision, which dealt with Rule 15. CompuTicket and many other cases, Travloska. So we have had a number of registered, a number of successes.
Now, the alignment of competition law and the constitutional law brings you closer to fighting for the consumer, particularly those who are least fortunate with regards to, of course, what will be at the center is whether these measures do affect the pricing and to what extent do they exclude the poor. And that should have emboldened you in terms of the kind of work that you do. How do you view, from a legal point of view, the kind of work that the competition does versus the expectations of the consumers, particularly the protection of those who are less fortunate?
Yes, it's a very difficult role that the Commission has to play in terms of balancing the various competing interests. In the sense that the main interest of consumers is in lower prices. That's really their main interest. But as competition regulators, we have to look at the issues holistically. There are costs, there are production costs that have to be taken into account. There are questions of return on capital that have to be taken into account. There are questions of risk investment. So it's really a role which really needs the skill of a trapeze artist in balancing very carefully these various interests. Because if you go with too much of an interventionist approach, then you chill investment. But if you go with an approach, a hands-off approach, you then create a fertile breeding ground for exploitation of market power. So it's a role that really requires a very delicate balancing act. Yes.
And talking about that interventionist approach, also the law requires of you to take into account of public interest, which has become a very topical issue lately, because also you still have to take into account of the other interest that you're talking about, which is market power and issues of investments. How then do you balance public interest, but also in terms of competition law? But also, there's also a view that in any case, the competition law is in the public interest. So how do you then differentiate the two, or how do you align them? And why is it important that we do have those public interest issues in our mandate as the Competition Commission?
Yeah, fortunately, within our framework, because the concept of public interest it can be, to use a cliche, it can be an unruly horse. So fortunately for us, the Act has clearly demarcated the public interest grounds, cognizable in terms of the Act, where, in terms of how the competition authorities can intervene in markets. So there is a clear framework. Of course, I think we are quite right that we have not yet developed a clear framework on how to balance competition as well as public interest issues. And we see a lot of that tension between competition as well as public interest issues in various major transactions. You see that tension between competition issues as well as public interest issues playing itself out. But this is really a challenge now for the next 25 years as to how to balance this. Again, it's an issue of needing the skill of a trapeze artist. But you have to balance. Otherwise, if your approach is tilted in favor of public interest to the detriment of competition, then you are likely to produce outcomes that may not be satisfactory.
Mm. You have registered successes, and a number of them have been highly publicized. But what are the challenges that we have seen and that you think need to be refined with regards to the kind of work that we do from a Competition Act point of view, the competition law point of view, that have really posed challenges in terms of your litigation strategy?
Yeah, in terms of litigation, I think the system has not lived up to its promise, because the reason why a parliament established specialist institutions, a specialist commission, specialist tribunal, a specialist court in the form of the Competition Appeal Court, was to secure efficiencies in terms of speed and turnaround of cases. So the system has not really lived up to those promises. In fact, if you look at our litigation now, we have, for instance, cases taking between 5 to 10 years before they are finalized in the tribunal, competition appeal court, and now the Constitutional Court. So I think we have to find a way. Of course, this is not unique to competition litigation. You know it within the context of criminal litigation. There is that challenge as well, civil litigation, even in other jurisdictions as well, US, Australia, the EU. The problem is still there. So we do need to find, I think, a formula that is able to secure efficiencies in terms of outcomes, of course, whilst safeguarding the procedural rights of firms prosecuted by the Commission.
But sometimes one may argue the fact that sometimes when there are lawyers involved, and given the fact that they make their money through representations and going to court, that's where the bulk probably of their fees come from. And if there would be a process of mediation, maybe before that, the system itself may be much more efficient and much more speedily in terms of resolving these cases. But by the nature of how sometimes lawyers make their money, they tend to prolong that. Is there any truth in that perspective?
Well, I've also been on the other side, representing clients. Of course, the primary role of a lawyer is to safeguard the interests of your client, to ensure the best outcomes for your client. So it's not necessary to make fees.
But they must eat.
Yeah, but to really safeguard your client's interest. And in fact, lawyers have provided a very constructive role because the corporate leniency applications that you get, those are actually triggered by legal advice. The settlements that you get, and by the way, as we all know, settlements have been the main driver of outcomes, not necessarily contested litigation, but settlements have been the main driver of impact. So even those settlements, lawyers have played quite a constructive role in ensuring that those settlement agreements are secured. For instance, I can just make reference to the construction fast-track settlement process, which was one of the biggest mega projects that we did in terms of addressing industry-wide collusion. The bread cartel, the settlements that we secured there, it's really, they were secured on the basis of constructive engagements with legal representatives. So lawyers don't always play a negative role. In fact, they in a sense, they are working with the regulators.
With the authorities. But
yes.
where you don't find an agreement and you end up in court, in those few cases where the decision have been against the Commission, I mean, are there certain rulings that come to mind that had an impact in terms of how we conduct our litigation or do our business?
Yes, certainly. As I said, it's very important that we don't, as competition regulators, we don't react psychopathically to criticism from the courts, but we use those decisions to actually enhance our investigations, our referrals, the quality of evidence. So there are a couple of decisions, but the decision that comes to mind is the uniplate decision of the CAC on the standard for exclusionary conduct. You see in that decision an emphasis on evidence of effects in that particular case, so that you don't run, as competition authorities, we don't run a theoretical theory of harm, even though it's a mixing my metaphors. Yeah. Yes, but a theoretical case. You don't run a theoretical case, but you run a case that is grounded on evidence. I think that's really one of the key lessons that we have learned from some of the decisions which have not gone in favor of the Commission, that we have to ensure that our approaches are anchored on evidence.
And then moving forward, looking forward in terms of your litigation, what do you think would be, having taken into account of what we had just said, will be the primary areas of focus from a litigation strategy going forward?
On litigation, of course, there are a number of phenomena that have emerged or are beginning to emerge. We are seeing the trend of exceptions, where cases get stuck on exceptions. That trend is likely to continue unless we find a solution to that challenge, because then a case does not get heard on the merits. You get a legal contestation around exceptions, which goes on for years. I think we have to find a solution to that. What we are also seeing, because cases are taking longer in terms of being finalized on the merits, we are now seeing a proliferation of interim relief applications by firms themselves in the tribunal. I think there's a need to expand the scope of who can bring interim relief applications to also include the Commission, because complainants may not necessarily have the resources. You've talked about legal fees, the resources to bring these applications. So interim relief, I think, going forward, will play a big role in terms of securing speedy remedies whilst these cases are dragging. Market inquiries are much quicker in terms of securing outcomes than litigation. So because of that advantage that you get in a market inquiry as opposed to outcomes through litigation, you are going to see a lot of contestation, especially on decisions in market inquiries that may be controversial. You are going to see a lot of litigation around that.
Given the fact that, by and large, the competition or the Competition Commission is fighting or is litigating against people who have deep pockets, and they are likely then to delay and delay and hoping that you are going to get tired. You have pressures, budgetary pressures, you have got public pressures. How do you think then that should be dealt with? Because it seems as though the opponents of the competition commission would have found that in order to fight or to engage the commission, play a merry-go-round as much as you can, tire them up, and probably force them into some form of agreement which would be in their position, or tie them out as much as you can. To what extent is that strategy frustrating for you?
No, certainly. I mean, it is frustrating, not just to the commission, but also to complainants as well. So legal gaming will continue to be part of a part of competition litigation going forward. There isn't a doubt about that. So I think what we probably need to do is to look at which areas in the litigation process require some reform. And it seems as if cases get stuck mostly at pleading stage. That is at the stage when there's an exchange of papers. That is where cases get stuck. Because at pre-trial stage and at trial stage, you don't see sometimes there could be, but it's not as, it's not as severe as in. So I think we have to find a way of reforming that pleading stage to ensure that cases don't get stuck at pleading stage. So I would suggest here that we seriously look at legal reform. Of course, the high courts have this case management system, but it has not really produced a speedy resolution of cases. But it's something that we could look at borrowing, a case management system, such that when a matter is referred to the tribunal immediately convenes a pre-hearing to determine the steps of the rest of the process. Because currently the tribunal is not really involved at that stage. And that stage, it's left to the parties to determine the pace of litigation at that stage and the exchange of papers.
Maybe my last question. The commission has emerged as a center of excellence. The output by the staff, the vision by the leadership, and the commitment by the generally by the family in the institution. To what extent does leadership play a significant role in giving direction to the commission, particularly in the next 25 years? What do you think are the issues that lie ahead?
Leadership is everything in various contexts. It's really everything. So of course the challenge for leadership, because there is so much to do, but little time, little resources. For a competition regulator, the most important thing is what are the priorities for competition regulation in the next 25 years. And those priorities must be linked to the key challenges that the economy is facing. As you know, we have been on a low growth trajectory for over 10 years. The Minister of Finance re-echoed this point in the budget speech. And that has all sorts of consequences. The low growth trajectory, high unemployment, low levels of investment. And we are also seeing this phenomenon of deindustrialization in certain important sectors where we ought to be leading. We are seeing deindustrialization. And with deindustrialization, remember, you are also, in a sense, exporting jobs. Because if you are just shipping the raw materials to China and to elsewhere and not beneficiating those, you're also exporting jobs. So competition policy must be able to respond to these issues. So I think for me, that's really the key challenge. The key challenge for competition regulation is that it must not be an inward-looking approach, but it really must be a context-sensitive approach to competition regulation that actually looks at what are the critical issues in the economy where competition regulation can serve as a catalyst or at least contribute to the growth of the economy.
No, thank you. Anything you want to say that we haven't covered in the last few minutes?
Yeah, the only thing which I can say is that, this is a very great institution. And it's very important that it should continue to play a constructive role in the economy, with emphasis on playing a constructive role in the economy. Thank you.
Thank you very much. Thanks for your time once again. Thanks, Mike. Good day, my name is Sipongwe. I'm head of communication at the Competition Commission. The Commission celebrates 25 years of its existence, and we look into the beautiful work that it has done, some significant milestones, and we talk to a number of executives inside the Commission.
Thank you.
Is that okay?
Has anyone got notes?
No, that's good.